Yes, sir.
Good morning. If it pleases the court counsel. My name is Kerry McGuinn Jr. I represent the petitioner in this case, who is Jonathan Hall, MD. Dr. Hall is the plaintiff in the case below. He was previously sued in a medical malpractice case. That case went to summary trial proceeding before a retired judge. It resulted in a judgment against Dr. Hall in excess of $10 million as a result of a surgery where a patient ended up paralyzed. Subsequently, Dr. Hall, represented by my office, filed an insurance coverage action against Mag Mutual Insurance Company, which was his insurance carrier in connection with the underlying claim. In the course of that litigation, through discovery, it was learned that there had been allegedly a communication with another insurance carrier, which insured Baycare and insured my client through Baycare. That insuring entity maintained claim notes in the form of a computer diary system. Now, as you will note from our petition, the issue in this case, we filed a petition for certiorari. The trial judge ordered production of a single page portion of those claim notes from the other insurance entity, the Baycare insuring entity. And that is why we filed the petition for certiorari in this case on behalf of Dr. Hall. It is our contention that that note, which is referred to commonly as the Baycare note in the papers in this case, represents an attorney-client privilege and work product privilege communication.
Now, Dr. Hall did not send the note, is that right? He has disclaimed any actions as far as sending the note. He didn't do it.
That is correct. And when Your Honor refers to sending the note, to clarify what the note represents.
Calling in the claim to the insurance company. I misspoke on that.
Yes, sir. And there was somewhat of a level of mystery surrounding the origin of the note. As we noted, I believe in our papers, the adjuster who testified regarding the contents of that note from Baycare indicated that it was from a legacy system, so they did not have a record of who is the person who made the phone call to Baycare. They did not have a record of who is the person who received the phone call at Baycare. What they had is a typed summary of which was filed under seal, and the court has had the benefit to review, but my colleague here on behalf of Mag Mutual has not seen, because we withheld that under an agreement to stay the trial judge's order. But there was some mystery surrounding exactly who made the call and who took the call.
It seems to be now resolved that one of the office managers, Calvasani, made the call. Is that right?
That's the allegation, although Dr. Colpasani's brother, who's the office manager, indicated that he has no memory of making the phone call, and the Baycare claim representative testified that they thought that it was Mr. Colpasani's brother, but they did not have specific documentation of that. But I think for purposes of today's argument, that is not important. And let me tell the court why. Because one of the threads that runs through the argument of the respondent is that, well, because Dr. Hall doesn't have a specific recollection, or because of what they characterize as Dr. Hall disclaiming making the phone call or telling somebody to make the phone call on his behalf, somehow that results in a waiver, somehow that results in a loss of the privilege. And I would suggest to this court, it's really unworkable to interpret attorney-client privilege in the rearview mirror based on the subjective point of view of the person now. And I would make an analogy. If you look at case law related to offer and acceptance as to whether there's a settlement, typically what the court does, it looks objectively at the documentation. Was there an offer? Was there acceptance? So that we're going to enforce a contractual arrangement. In many of those cases, you have people in hindsight, sometimes years later testifying, well, this was my intent. Well, this was my memory. Well, this is what I wanted to happen. Well, this is what I wanted to do to result from this. And in the same vein, it's unworkable. The court needs to objectively look at the document, I would respectfully suggest, to determine whether or not the document itself encompasses what appears to be a conversation that would fall within the attorney-client privilege, because there are a whole host of examples where someone could come back years later and look at the subjective interpretation of either the client or the attorney years later to determine whether or not it's privilege. An example is, what if you have a situation where you have an individual who's injured and has no memory of making of the conversation? What if you have someone who indicates, I did not specifically instruct this person to do this, but that was a person who was in a relationship with a person who made the statement, and it would appear from the nature of the statement that the information did come from the person. So it would put the court in a position of having to interpret and having to say, well, are we going to decide there's a waiver because we think someone forgot? Or are we going to decide there's a waiver because we think someone is saying now they didn't intend this outcome? I would suggest the more workable and logical way to address this would be to look at the substance of the statement in the context in which it was made, at the time it was made, and make a common sense determination as to whether or not it appears the statement reflect the words of someone who is seeking the advice of counsel. Now, if I may, to move on.
Counsel, there's a difference between the fact of somebody wanting to seek the advice of counsel and actual communications between that person and between counsel, correct?
That is true.
Like, communications are absolutely privileged. There's no dispute about that, right?
I think I would agree with that statement, but
As a general matter.
yes, but to the extent the court is suggesting it has to be a direct communication, I don't think that's the law. I think the law also says you could have an indirect communication that would fall within that scope.
But I'm not talking about, I'm distinguishing not between direct and indirect communications, but I'm distinguishing between the substance of a communication and the fact of a communication. Sort of like when you're talking about hearsay, and when something's not being offered for the fact of the matter asserted. And isn't there a distinction to be made between the fact of a communication and the substance of the communication?
I do not think there is in the attorney-client privilege. I do not think it would be tantamount to comparing it to what the court's analysis just compared to hearsay. I think that if you look at the entire body of case law related to the attorney-client privilege, as we all know, it's a critically important privilege to the workings of our business and the legal system. And for instance, if you look at the substance of the statement in this case, to try and parse it out and say whether you have that level of intent, I just think it.
I mean, if I say to you, I want to talk to a lawyer, is that a privileged communication?
I think if you said it to me in the context of what would be a privileged setting, yes, it would. In other words, if you and I worked together and I was someone who was in a job position that entails facilitating that attorney-client communication, and you said that, I believe that that would be a privileged communication. I believe in other instances, if we were at a cocktail party and we were discussing things in general, and you mentioned, hey, I think I want to talk to a lawyer about this, to someone who's not in that position, I do not think that that would be protected by the attorney-client privilege. If I've addressed Your Honor's questions, I'll move on. Thank you. The other issue that I'm going to go ahead and delve into that I think is critically important to this case is the arguments that have been made with respect to the body of case law related to the at-issue doctrine and whether there's been a waiver.
Okay.
And I'll go ahead and address that, because if you look at their papers, basically they argue that essentially because Dr. Hall brought this lawsuit against Mag Mutual, somehow there's a waiver that he's injected this issue. And I think that that's an incorrect argument, because if you look at the relationship of the parties and the entities that were involved in this communication, in this case, you will see it. Importantly, it is not a note that was in the possession of Mag Mutual. In other words, it would be a completely different situation if Dr. Hall were suing Mag Mutual and Dr. Hall had made allegedly himself or through someone else statements to MagMutual itself that were memorialized in their files. Baycare is a completely separate entity, is a completely separate party. There's no dispute in this case that the occurrence is a covered occurrence under the policy. The issue is whether an exclusionary provision applies. And there's an abundance, if you look at all these cases that we've cited, there's numerous cases where someone just brings a lawsuit and then the argument is made. Any possible legal issue that dovetails out of this lawsuit for any reason would be construed as a waiver. It's very similar to the cases that we cited in our papers that involve legal malpractice actions against law firms, where the law firms have tried to argue, well, there's a waiver, we want to get at certain information. And these are all issues in those cases, the Wolf case and the other cases we cited. These are all issues where the defense has raised a defense to the plaintiff's claims. And the court said, stop, this is not the same as the plaintiff creating an issue and trying to make an argument that advances their claim on the one hand, but trying to shield evidence or information that would undermine the basis of their cause of action. And so MagMutual has the burden of proof on their policy exclusion. MagMutual has raised that as a defense in this claim, and similar to the legal malpractice cases that we cited in our papers, the mere fact that Dr. Hall himself has filed this lawsuit against MagMutual does not in any way, shape, or form place what happened with Baycare as a basis of underpinning his cause of action. That's a defense that they've raised. That's an avoidance that they've raised. So to characterize that as being a waiver or invoking the case law related to the at issue doctrine misapplies what the facts are in this case, as I conceded to the court. If these were materials or communications that had occurred with respect to MagMutual itself, it would be a completely different scenario. But if you think about it, you've got a policyholder, a claimant who brings a claim under one insurance policy. So the insurance company engages in discovery, they go out and they find certain information that's allegedly in possession of another insurance company. How could that information be characterized as being the basis of Dr. Hall's claim when it's undisputed that it's a covered event? And the only dispute is whether or not they can invoke a policy exclusion. So, to permit that, if you take that to its logical extreme, you can think in any number of cases, not just limited to insurance cases, where people have had communications with attorneys in other settings or for other reasons that is not necessary to prove up their claim, but it may very well, I would concede, this type of information in many of these cases may very well inure to the benefit and help the defendant develop defenses that could defend them on and assist them in bringing the policy defenses that they're asserting in the case. But to permit breach of the attorney-client privilege for those reasons would essentially gut the attorney-client privilege. And with that, unless the court has any further inquiries for me, I'll stand down.
All right, sir, you've got about 6.5 minutes left.
Thank you.
May it please the court, Dinah Stein on behalf of MagMutual. And Dr. Hall brought this coverage action on a policy that forbade a claim being made if it was reported to a prior carrier. He attached the policy to his complaint. He avoided summary judgment by contending that the very notice that was given to his prior carrier was not in the nature of a claim, but has prevented MagMutual from having that notice. And the trial court saw this. Judge Meyer is very familiar with the issues. And it was when he heard the summary judgment motion that he recognized that Dr. Hall was using that note that he had originally required to be redacted as a sword and a shield. And he said, I am going to review it in camera if the proper inquiries made. And that's what he did. He reviewed it in camera. He was very deliberate about this. And he said that he held that the privileges that Dr. Hall is claiming do not apply. Now, just to jump into the at issue doctrine, because I want to distinguish the Coates case and the Volk case and the cases where essentially a party brought generally an affirmative defense and tried to get privileged information to support that defense. This isn't what has happened here. The MagMutual has not been on a fishing expedition. It has not asked for the entire claim file. We're talking about one note, which is dispositive of the issues. And so we contend this case is much more similar to this court's decision in 2020 in the Owners Insurance versus Armor. In that case, there was a single issue regarding notice, and for that issue, that was enough to get past the privilege on just that discrete issue. So number one, we contend that the court need not even address the privilege issues because Dr. Hall has placed this issue as a dispositive issue in the case, and the judge recognized this below. As far as the alleged privileges, and I asked rhetorically as far as attorney-client privilege, whose privilege is this? Because Dr. Hall, as Your Honor pointed out, has affirmatively disavowed any part of the report that undisputedly was made to the prior carrier. That's not disputed. It was made, there's a record of it. He has said in an affidavit, and he continues to contend, that he had nothing to do with it. He didn't authorize it. It was made, we know, by Chuck Kolbasani, who was the office manager. And just as far as the record on that, originally the Baycare corporate rep testified that Dr. Hall made the report. She filed an errata saying it was Mr. Kolbasani, and there's been no evidence to the contrary. Mr. Kolbasani has not denied that. So it appears very much that Mr. Kolbasani, as the office manager, made this report for the reason, and I am, he hasn't said this, but to trigger coverage under the prior policy, that the office didn't want to have a problem with the Lexington policy because they knew this was a very problematic incident that occurred. Mr. Kolbasani has testified, and this was discussed in the hearing on the motion to compel, that he's not a doctor. He wouldn't have been able to talk about the medicine. So this is something that was just a report, would have been made to the prior carriers to put them on notice. But I would submit that a litigant cannot disavow themselves from a communication and then try to use a privilege, an attorney-client privilege, when they're not the ones who made the communication. Baycare isn't here in court. Dr. Kolbasani is not here in court. The office is not here in court. If there was a privilege ever, it belonged to one of them, or maybe not Baycare, but the others. No one's asserted it but Dr. Hall, and he's disavowed himself from that privilege. So there's no attorney-client privilege. As far as the work product privileges that have been asserted, and I'll just point out to the court, originally there was a claim made that this also fell under attorney-client thought process, opinion work product. And that's been withdrawn. And I think, and I speculate on this, but I think the reason it's been withdrawn is probably because no attorney has ever been identified as even reading the note as communicating with anyone in regard to, I say the note, the report. No attorney's ever been said to have had anything to do with that report. But as far as the work product, we know that this is not an attorney's file. This is a claims file from the prior carrier. As far as the claims file alleged privilege that has been asserted, and of course there's no bright line claims file privilege, it's work product. And that privilege has been applied in a limited circumstance, and that is when coverage is at issue. And we know it is undisputed. Coverage under the Lexington policy is not an issue. It is done. They never disputed coverage. They pay their policy limits. It will never be an issue. So there's clearly no claims file privilege. If there was, it would belong, I submit, to Baycare or to Lexington, not to Dr. Hall. And all of that leads to, I think, a very fatal problem with this certiorari proceeding, is that if he didn't make the report and he didn't talk to the lawyer and he didn't use any of these materials that we're trying to get in part of his defense, he doesn't have standing. And if he doesn't have standing, he can't claim an irreparable harm. So I would submit on certiorari, this court doesn't have jurisdiction to entertain this
If we agree with you
petition.
on the standing issue, does that implicate our jurisdiction to handle a certain claim?
I believe under the third district's decisions that, yes, that would be dispositive on this court's jurisdiction and specifically cited to,
Jimenez case?
I'm sorry, Your
The
Honor.
Jimenez case? Is that-
Yes, Your Honor, thank you. The Jimenez case does stand for the proposition that if somebody without standing in a discovery dispute like this petitions for certiorari, that it is dispositive of this court's jurisdiction and there just is no jurisdiction. We would ask the court to follow Jimenez and hold as much. But in any event, we would ask that the court either dismiss or deny the petition. And as we asked in the lower court, I hope we don't have to get to this, but we ask alternatively, you know, if Dr. Hall is going to be precluded from taking the position that he didn't make a claim, you know, perhaps we could go forward without the note. But as Judge Meyer found, we need the note. It is absolutely critical. The plaintiff hasn't shown that it's privileged or that there's any problem with disclosing it. And we would ask that this court either dismiss or deny the claim. Thank you, Your Honors.
Thank you, counsel. Response?
Yes, sir. If I may respond briefly to the standing argument, we've cited case law in our papers. The attorney-client privilege belongs to the client. And it is, I understand it is difficult because my colleague does not have the benefit of seeing the note that's been filed under seal. But the attorney-client privilege is something that belongs to the client. It would not be appropriate and proper for an office manager such as Mr. Kolbasani to have to retain counsel, someone who's not a party to this case, to have to retain counsel to appear, to have to assert the attorney-client privilege on behalf of someone like Dr. Hall. The context of the communication is very important. The context of the communication is the office manager of a doctor's office where someone has just come out of surgery and been rendered paralyzed, allegedly has a communication with that doctor's insurance company, another insurance company. So it would seem to me to ignore that and to make a technical standing argument that we don't have the office manager in here, we don't have somebody else in here, would ignore the spirit and the tenor of the many cases that say the privilege belongs to the client. So Dr. Hall clearly does have standing under the law to assert that privilege. It's not dependent on either Mr. Kolbasani or Baycare coming into the rescue. The last thing I would address is it's somewhat of a catch-22 because it would seem under the law that for the at issue doctrine and waiver to apply, you need to have a privileged communication or document in the first place. Otherwise, we're wasting our time talking about waiver and talking about whether you placed it at issue. If it's not privileged, it's like everything else that we deal with in discovery in these cases, whether it's reasonably calculated to lead to the discovery of admissible evidence. And so I would suggest that they're trying to have it both ways on that issue. When you do look at the arguments they've made on that issue, it's very analogous to the cases we cited in our papers, particularly with respect to the Ackerman case and the language we quoted. The court specifically said in that case, the lawyers have not shown that the clients must necessarily offer the disputed documents at trial to prove their claims. I wholeheartedly agree with my colleague that it would likely help their defense. But that's not the standard. The standard as to whether there's a waiver under the at issue doctrine is whether that disputed document would be essential for Dr. Hall to prove his claims. And it's not. It's solely related to an exclusion that they've raised. Dr. Hall merely has to show that the loss occurred within the scope of the coverage provisions of the MagMutual policy. And they've raised an exclusion. They've basically argued, well, if you report it to another insurance company, we have an exclusion in this policy that says you don't have coverage. And so I concede that it would assist their defense if they go out and they gather evidence, including evidence that's allegedly privileged, that would help them advance their exclusion, but that's not the standard at all. The court concluded in the Ackerman case by saying the lawyers cannot, by their assertion of a comparative fault defense, create a waiver of the client's attorney-client privilege. That's exactly what they're trying to do here. They're raising a defense and they're saying for us to oppose that defense and overcome it at a summary judgment hearing, that we're doing the sword and the shield. We're not. The sword and the shield relates to whether or not we would need that to prove our claim against them, not to defeat their motion for summary judgment. And with that, I'll conclude my remarks unless there's any further questions.
I think we're good. Thank you, counsel.
Thank you.
Thank you both. very
Thank
much.
you.
Next up is Lee County versus -40 Technologies et al.